see all the time, the backlog in courts, David.
Yeah.
They're working to accelerate having a case go to trial.
Right, yeah. So one of the challenges that we face is the length of time it takes for cases to get to trial. So you could, if you're talking about a personal injury case, if you went down to the courthouse in Ottawa here today, the cases are probably from accidents that may have occurred in 2012. So you're looking at 7 years, 6 years, 8 years. That's pretty common from the time an incident occurs to the time it gets to trial. And there's a lot of reasons for that, but there are some things that it's felt could be done to sort of speed that process up.
So if someone has been severely injured in an accident and
Yeah.
they're still waiting for potential compensation from
exactly.
an insurance company, that can be, and they're unwell, the stress of waiting for something to go to trial, I'm sure you see that on a daily basis as well, is overwhelming.
Yeah, it becomes an access to justice issue where just people sometimes they can't wait or whatever. So
that's personal injury. Sorry to interrupt you there, but we've also seen cases thrown out because of the delay in them getting to trial.
Right. So, I mean, the courtrooms are pretty much all the same down at the courthouse, and you've got limited resources. And so what happens is there are criminal cases. R versus Jordan was a big decision where, basically criminal charges can even be dropped altogether if the delay is too long. And so for civil cases, which is what I mainly deal in, sometimes they even are lower on the priority list. If you've got an urgent criminal matter or an urgent family law matter, sometimes they take priority. But so the civil cases often take even longer.
So what's being suggested?
Well, one of the causes for the delay is that a party has the right to elect between having a case heard by a judge alone or a judge and jury. And so I can tell you, having been down at the trial management court last month, and we're booking trial dates off in the future. And by the way, in 2019, we're booking cases off in 2022, 2023. And these are cases that are ready to go, that have been through the rest of the litigation process. When we're trying to book a date, the judge will ask, well, is this judge alone or is it judge and jury? If it's judge and jury, the judge will inevitably tack on 1, 2, 3 weeks, because jury trials are way slower. So one of the suggestions is that for certain cases, let's say that are less than $100,000 or even $200,000, those are judge alone cases in every situation. And that can sort of speed things up. They become a little quicker, a little more efficient. That's the solution that's being proposed.
What about someone who's watching and is waiting for their case to go to trial? Will this impact their situation, or is it likely just to be for cases ongoing?
So typically there are transition rules that always get discussed, and every time the rules change, they change in the middle of some cases, and there are certain things that will apply to cases going backwards and certain things that will just be sort of from now on. So that'll be determined by the transition rules that the Ontario Civil Rules Committee will implement.
And one interesting note, and you discussed this with me in the commercial break, is more often than not, people will choose judge or trial by jury as opposed to by judge when you're in fact the defendant.
Yeah, there are a lot of tactical reasons why a defendant may want to have a case heard by a jury, certainly in motor vehicle accident cases where there are certain subtleties related to the Insurance Act that the jury will not know. But it's a case by case, but very often the defendants are the ones who ask for a jury in almost every case.